All right. Well, good afternoon, everybody. My name is Guillermo Beades. I'm an attorney here at Frier Levitt. I'm in the healthcare department. I do a little more litigation, but what I've been seeing more and more lately is that a lot of my clients who come to me would not have been my clients had they done a little bit of, you know, proactive measures. If they would have had a little bit um, of proactive medicine and taking care of some issues before they became problems, well, they wouldn't have met with me. They would have instead met with some of the other attorneys from my firm beforehand, such as Brandon and Romana, who will be speaking to you today about two very important issues, two very new laws. So this is really about preventative medicine for your practice. I'm going to thank you for taking the time to join us today. It's very important that you do join us today because as you all have heard at one point or another in your life, ignorance of the law is not a defense. And there are two very new laws that affect every practice in New Jersey, regardless of their size or area of specialty. Recently enacted was the out-of-network law. Brandon Zarsky will speak about that a little later during this program. And we're going to start off in a little bit with Romana Syed, who will talk to you about the recently implemented paid sick leave law. Now, what do these two laws have in common other than they're new? Well, unlike some federal laws, they don't apply to employers of a certain size, but rather to all New Jersey employers, regardless of their size. Doesn't matter what specialty you are, none of that matters. They both apply equally. Both are new, so a lot of people aren't really aware of their scope. You'll learn that the Paid Sick Leave Act is more than just getting paid for sick days. And you're going to learn also similarly how the out-of-network compliance law requires more than simply just not balanced billing. Each of these areas could be hour, 2-hour presentations of themselves. So we want to try to give you a little bit of comfort. We want to take a little bit of the mystique out of these new laws and make you aware what to look for and what you should start doing now. We're giving you this presentation today with the caveat that both of these laws are still evolving. There's new guidance coming out and further clarifications expected, particularly with the out-of-network law. But we can give you a pretty good understanding of what it means to comply with these today. And, as we tell all of our clients, whenever we get involved with a compliance plan for a practice or a consulting plan with them, anytime there's an update in the law, you'll hear from us first. So what I'd like to do first is I'd like to turn it over to Romana Syed. She's going to kick it off for us and talk about the New Jersey Paid Sick Leave Act. Romana has specialized knowledge and expertise with provider contracts, employment agreements, and healthcare-specific employment matters, such as the New Jersey Paid Sick Leave Act. I'll turn it over to her, and Romana, it's all yours.
Thank you, Guillermo. Thank you, everyone, for joining us today. Again, my name is Romana Syed. I will be kicking us off with our conversation about the New Jersey Paid Sick Leave Act. So this law actually on May 2nd was enacted, and it had New Jersey become the 10th state to enact a statewide mandatory paid sick leave law. The law is called the Paid Sick Leave Act, and it has gone into effect already as of October 29th. There are a few things that we do think that you have to be sure that you're complying with already. And while, as Guillermo said, that everything is still relatively new and that there is a lot evolving, changing, and developing, we have yet to see how things are going to play out, but we think that there are certain things you have to make sure to comply with today. Essentially, what this law is doing is it's requiring all quote-unquote covered employers to provide up to 40 hours of sick leave to their employees. just as a general definition, covered employers, this law is going to apply to any business entity, irrespective of size, that employs employees in the state of New Jersey. So this law is very broad. It's unlike the FMLA or the NJFMLA or the NJFLA, I'm sorry, that those two laws typically are limited to employers of 50 plus employees. But in this instance, again, it's going to apply to any employer irrespective of their size. It is going to exclude public employers that are already required to provide their employees with sick leave. In terms of the employees, covered employees, it applies to most all employees working in the state, quote unquote, for compensation. So as you can see, again, it's very broad. This would essentially include both full and part-time employees. An exclusion would be for employees in the construction industry under a collective bargaining agreement, per diem healthcare employees, and public employees, again, who already have the sick leave benefits. In terms of the mandate, the way it essentially works is that all covered employers will have to have a sick leave policy under which the employees would earn at least 1 hour of paid sick leave for every 30 hours the employee works. And what this essentially amounts to is 5 days in the year, so a total of 40 hours of sick leave for a full-time employee. The law essentially sets forth certain covered purposes for which the sick leave can be taken. You'll see that the reasons are pretty expansive and they don't even necessarily just cover sicknesses. The reasons would include diagnosis, care, treatment of an employee's own mental or physical illness, including preventative medical care. So that applies to you as the employee, but then it also applies to aid or care for a covered family member during their diagnosis, care, treatment, or recovery from mental or physical illness, including preventive medical care. Now, the definition of family member, again, is very broad. Basically, what the law has said is that a family member is defined as anyone related by blood or whose close association with the employee is equivalent of a family relationship. And by doing that, that essentially covers, when they say close association, it could cover grandchildren, it covers siblings, it could cover a spouse, a partner, etc. So it really opens up the window for a lot of opportunities for employees to be able to take time off under this particular reason. It also includes circumstances related to an employee or the family member's status as a victim of domestic or sexual violence. This kind of feeds off of the New Jersey SAFE Act. It also includes closure of an employee's workplace or of a school or child care due to a public health emergency. It also includes time that you would need to attend a meeting requested by school staff for a child's health condition or disability. So as you can see, it is pretty expansive. And, the law has stated that while this employee is on leave for one of these qualifying reasons, you cannot require them to find a replacement. And also, the one caveat to that is that if the employee is going to be absent for 3 consecutive days, you can require documentation to prove their covered purpose does in fact exist. But beyond that, there's not a lot of protection for the employer necessarily to know whether and what these reasons are. And in terms of how the employer would provide these hours, there are essentially 2 ways to handle this. There's what they call front loading and then accrual. Front loading is relatively straightforward. You would provide the full amount of the earned sick leave that the employee would earn over the course of the year at the very beginning of the benefit year. So for a full-time employee, the 5 days would be provided right up front. The other way to handle it would be to do it as an accrual. Sorry, bear with me a second. Would be an accrual, which the accrual for all employees, all current employees, has already begun on October 29th. And the way this would work is that while the employee works, they accrue the sick leave at that rate of 1 hour for every 30 hours worked. Again, like I said, current employees have already started to accrue this time. New employees would begin to accrue on their very first day of work, but they wouldn't be allowed to use that time until after 120 days. So one of the big questions that we're being asked is, what do you do in a situation where you have a lump sum PTO policy in place already? Would you accrue or would you front load? So at the end of the day, that's going to be a decision that you as the employer would be able to make. But what the bottom line is that you do have to make sure that you are designating these sick leave days in order to comply with this law. So you could opt to say that those sick leave days would be, say you have a PTO policy where you have 15 days of PTO time. You could designate 5 of those days as your sick leave days, or you could create a separate sick leave policy that would comply with this law and allow them to have 5 additional days. Irrespective of which way you decide to handle it, the most important thing is that you do keep a record of the employees earned sick leave and when they've taken it. This is something that the department can review, so you do want to make sure to keep a record of that. In terms of actually using the sick leave, the employees can generally use the sick leave in any increment. Your policy as an employer can dictate this. You do have to make certain, however, that the largest increment can't be larger than the number of hours an employee was scheduled to work. So for example, if the employee is scheduled to work an 8-hour shift, you can't require that the employee use their sick leave in increments of 9 hours. The law does require a reasonable notice to the employer, particularly in a foreseeable situation. Obviously, with an unforeseeable circumstance, the employee does need to. You can try to require the employee to notify you of the intent to use the leave as soon as practicable. With a foreseeable event, the requirement is that you can ask them for an advance notice of up to 7 calendar days. Note that this is less than what the NJFLA requires, which is typically 15 to 30 days, and FMLA typically requires 30 days. So this is much less time that they would have to notify you in the event of a foreseeable event occurring. Again, you can also require the employees to make a reasonable effort to schedule their sick leave in a way that doesn't unduly disrupt operations, and you can prohibit use on certain dates and require documentation if sick leave is not foreseeable on those dates. At the end of a given benefit year, the law requires that the employer either carry over or pay out any outstanding or unused sick leave that was accrued during that benefit year. And this carryover payout is based on the same rate of pay that the employee earns at the time of the payment. With a payout, obviously you could pay out any unused sick time at the end of the benefit year. Alternatively, with the carryover, you could carry forward any unused time into the next year, up to 40 hours of unused sick time. But the employer is not required to permit the employee to use more than 40 hours in a given year. So regardless of what you do decide to do, it is to your discretion, but we would recommend obviously that you do try to maintain a consistent policy for this. A few smaller scenarios in the event of a transfer of employment. So, for example, if a practice or a company is sold to a successor entity, the employee would retain any accrued sick time. In the event of a separation, so if the employer is terminating an employee, unless your policy requires it, the employee doesn't necessarily have to be paid out on any unused sick time. If an employee is being reinstated or rehired within 6 months, any unused sick leave that was accrued at the time of separation would be reinstated, unless of course it was voluntarily paid out. And how you handle that, of course, is going to depend on your policies. This act, similar to many others, does contain a prohibition on retaliation, so it prohibits employers from discriminating or taking action against an employee who requests a sick leave or files a complaint, communicates with any person about violations of the law, participates in an investigation regarding the alleged violation, or gives information to another person of that person's potential rights under this act. So one of the first things that we want to make sure that everyone does, if they haven't done so already, is to provide notice of these changes to all of your employees. Note that this requirement did go into effect in October, and by November 29th, it was required that the employers provide the notice of the changes to the employees. What we have here on this slide, you'll see, is the official notice that is available on the New Jersey Department of Labor website. We do recommend that this does need to be posted in a place at your workplace so that it is visible to all of your employees. And we would recommend that you provide a copy of this to all of your employees as well. And if it's ever requested again, to provide another copy as needed. Keep in mind that state law preempts local laws. So in a situation where local law requires less than this amount of sick leave, you are still expected to comply with at least a state. And then in terms of enforcement action, just keep in mind again that noncompliance could result in certain enforcement action. Employees are permitted to file a complaint with the New Jersey Department of Labor and Workforce Development, and any lawsuit could potentially result in actual damages suffered, which would be the owed wages, plus an equal amount of liquidated damages. In terms of next steps, obviously, as we said before, keep in mind that this is still very recent. We're watching it evolve every day, and we'll need to keep watching it to see how it's handled moving forward. I know that there have been a lot of questions in terms of employers that do have a PTO policy already, so we're going to have to see exactly what this is going to mean for all of you. But ultimately, we'll have to keep. The few things that you do have to make sure you comply with already is, make sure you give your notice to your employees, make sure you post the notice that we showed you on the previous slide in your place of business, and start taking a look at your PTO policies as well as your employee manuals and any employment agreements to make sure that everything is in compliance with this act, especially in terms of the sick days, making sure that you have your designated number of sick days, determining whether any unused sick time will be accrued at the end of the year or paid out. These are things that you do need to start keeping in mind. Again, like I said, one of the big questions has been the PTO policies that are already in place. If you have one in place already, while you don't necessarily have to change the whole thing, we do remember just request that you do try to keep a designated number of sick days aside for these employees, and that you do track this. Ideally, I think that you do want to try to consider having a separate sick day policy, but again, it's going to determine it's going to be determined based off of your policies already. So start looking at those, and obviously, if you have any questions for us, feel free to reach out to us. With that, I will turn it back over to Guillermo. I believe we'll be saving the questions until the very end.
Yes. So the way we're going to do this, so everyone knows, is you can keep submitting your questions, and obviously, if we have time to get to all of them, we will. If not, what we're going to do is we're going to prepare essentially almost like a little FAQ type of Q&A document that we'll send out to everyone that includes everyone's questions from this webinar, because obviously there are a lot of issues with new laws. We're still trying to find out every bit of detail about them. As you could tell, this is a very fluid situation, and we can certainly understand, the confusion, the many questions that you have. And then, of course, Romana and Brandon will be, helping prepare all the answers to those questions. The one thing, Romana, that I just wanted to just ask you if you can expand on, obviously these are essentially the floor. I mean, if someone wants to have a more generous or a better policy, they can give even additional sick days or more time, correct?
Yeah, absolutely, absolutely. I mean, the bottom line is that this is your minimum. This is what you absolutely must have. Beyond this, obviously, if your policy already allows for more time than this, then that's great. There's no reason to obviously change it. It's just a reminder that this is the minimum.
And the reason you suggested that they separate almost, we'll call it normal PTO for lack of a better word, from these paid sick leave days is because the paid sick leave days can be carried over, correct?
Exactly. So the paid sick leave days, they need to be tracked for purposes of the department as well. We need to make sure that we're tracking those days so that we know we can prove in case there's ever a question that those days were given, and also because those days can be potentially either paid out or carried over. Oftentimes we see our clients where if they have PTO policies, they may also have a policy where any unused time doesn't carry over and they don't get paid out on it. So for that reason, you do need to make sure to have that designation for this specific sick time.
All right, so what we'll do now is I'm going to turn it over now to our next presenter, and then again with the understanding that if we have time for questions at the end, we'll try to do that. Our next presenter is Brandon Zarsky. He's an attorney here at our healthcare department. He does a lot of corporate and regulatory work. He's in our corporate group and our regulatory group. So he's involved with a myriad of regulatory and compliance issues. And most recently, he's the brave soul at our firm who's taken a deep dive into this massive new out-of-network law. He really is one of the few attorneys in the state that understands the intricacies of this law and its wide impact. And when I talk about the wide impact, Brandon will obviously explain it in much better detail and much more eloquently than I am, but it's very important for everyone to know that you may be a in-network practice, you may have a lot of in-network patients, but if you do have even a small percentage, even the odd out-of-network patient, this law applies to you. And it is a bit of a bear. It requires a lot of different notices. It requires a lot more than just not balanced billing. A lot of notices are involved, transparency, and I'm going to turn it over to Brandon so that he can give you a little more on the out-of-network issues.
Thanks, Guillermo. Hey, everybody. Thanks again for joining us today. My name is Brandon Zarsky. I'm an attorney in the Corporate Regulatory Healthcare Group at Frier Levitt. As Guillermo mentioned, I'm going to be kind of doing a 10,000-foot view today on the new out-of-network Consumer Protection, Transparency, Cost Containment, and Accountability Act. I'll probably just refer to it as the Act, the law, or the out-of-network law during the course of this presentation because that name's a bit of a mouthful. But just to real quick, and Guillermo had mentioned this before, but this is a pretty big law, and it impacts providers, facilities, health insurance carriers across the state, and I really could go into an hour, 2 hours, 3 hours talking about all the little requirements, all the specific timing of everything, and sort of how everything plays out as it applies to providers, facilities, or carriers, and how the requirements are sort of interchangeable and relate to one another. We don't have time to do that today, but we want to make you aware of this and sort of the general requirements. That way you can take steps to sort of make sure that you're in compliance. As the slide states, the act was signed into law on June 1st by Governor Murphy, and it became effective actually on August 30th. And the general stated purpose of the law is to enhance consumer protections related to out-of-network healthcare charges, and it affects healthcare facilities, professionals, and health insurance carriers. I will note that in addition to the out-of-network stuff, it actually also imports some other federal requirements that previously had only applied to Medicare and Medicaid beneficiaries. We'll talk about those a little bit later, though. So, what does the Act require? So, when I talk about the Act, I basically try to usually break it down into 3 general sections, and these mostly relate to each other, with the exception of some stuff in the miscellaneous other provisions section there. So, the first big one, which relates back to the billing restrictions and other requirements, are the disclosure requirements. Now, like I stated before, these vary depending on what you are, whether you're a healthcare provider generally, whether you're, and when I say healthcare provider, the Act defines it as all licensed New Jersey healthcare providers. So PAs, nurse practitioners, physicians, anyone with a license is going to have to make these disclosures. B, requirements specific to licensed New Jersey physicians. I'll probably go into these a little bit more later, but these apply just specifically to physicians. Then there's requirements for healthcare facilities, which are include hospitals and ambulatory surgical centers, as well as health insurance benefit carriers. So those include state agencies and obviously your private payers. In terms of the next section, these deal with billing restrictions. So these are scenarios where the law states that providers cannot charge what are referred to as the patient, or in the Act they're defined as the covered person, more than they would have been responsible for had the facility or provider been in network, and we'll get to that a little bit later. The last section is what I call the miscellaneous other provisions. These kind of relate back in some ways, and then one of them, which I'll talk about later, the ban on waiver of cost sharing amounts, is it's really sort of its own little mini law that they tucked into this. In addition to that, there's actually a new binding arbitration and dispute resolution system which ties back to those billing restrictions and is supposed to be intended as a way of sort of resolving disputes between providers, patients, and health insurance benefits carriers on the appropriate amount that can be billed if inadvertent or emergency out-of-network services are provided. So, to go back to disclosure requirements for a second here, like I said, I'm not going to go into super depth with these because I could really talk to each of them for quite a while here, but I do want to sort of flag a few initial things for each of these little groups. So, in terms of all healthcare providers, one thing I will say is that there are actually general requirements that all providers now all New Jersey healthcare providers need to make, regardless of whether or not they're in or out of network. These are pretty basic and can be included on your website. They include things such as the benefits carriers and facilities that you're affiliated with. In addition, there are specific other disclosures that need to be made when the provider identifies that a given patient is requesting services that would be considered out of network under their health benefits plan. In addition to the general disclosures and out of network disclosures that all providers need to make, there are also some specific physician disclosures. These tie into a couple of circumstances. For example, when you make a referral to another physician, you would need to provide the patient with that physician's address, phone number, and contact information. That way, the patient, along with some additional disclosures, that way the patient can contact them about determining whether or not their services will be in or out of network. In addition to the specific provider disclosures, the ones that need to be made by people, there are also ones that need to be made by facilities and health insurance carriers. These are actually a lot more verbose and a little bit more in-depth than the disclosures that need to be made by physicians. For example, healthcare facilities need to list a lot more stuff on their website, including a list of all their standard charges and a number of disclosures set forth in the Act. In addition to that, they're also required to provide patients with some pretty complicated written disclosures, which, include the patient's rights in terms of, receiving involuntary out-of-network services, their rights in the situation that they're in network with a facility but out of network with a provider they receive services from there, and that sort of thing. And then health insurance carriers, this is definitely a big one. They also need to make a lot of disclosures, including, providing hotlines for their customers / the patients to sort of call in and get information about their health benefits and, whether or not certain provisions of the Act will apply and whether or not they meet certain requirements, as well as, a number of additional disclosures just related to sort of an individual patient's sort of rights and whether or not, they are entitled to be protected under the Act in certain scenarios. For health insurance carriers, and this is actually a good segue here, but also something that I should point out, the various medical boards in the New Jersey Department of Health are handling A through C here, so the stuff for the providers and facilities, but the New Jersey DOBI, or the Department of Banking and Insurance, is promulgating regulations and guidance for the health insurance carriers. DOBI has already released some very basic proposed regulations and has released some very basic guidance, which is available on their website, specific to carriers. For those insurance carrier representatives on the line, we highly recommend you take a look at those, and also, contact your attorneys about just, making sure that you're in compliance with those, because they are somewhat voluminous and can be a bit complicated to understand. All right, so just kind of stepping back, this slide, I already sort of talked about it, but essentially, these disclosures can vary and vary between disclosures that need to be made generally, disclosures that specifically need to be made in writing, disclosures that specifically need to be made on a website, and disclosures that need to be made either, at the time an appointment with a provider is scheduled or at the time services are provided. One recommendation we do have, however, is that wherever possible, if a disclosure can be made, either in writing or verbally, we're recommending that you provide it in writing, get a disclosure form with an acknowledgement in it that notes that, the patient understands their rights, you've given them the disclosures that you're supposed to give them. If the form incorporates them, that's great. And just an acknowledgement that, they know they're responsible for any out-of-network charges or, anything else under the Act where, you could basically get in trouble for not being able to prove that you did give a proper disclosure to a patient. So why disclose? Well, two primary reasons. A, penalties and negative board enforcement action, which is a little bit more obvious, but B, the Act says that, if you don't make these disclosures, and unless the patient knowingly, voluntarily, and specifically selects you as an out-of-network provider to provide services, then you're prohibited from charging the patient any out-of-pocket expenses above those which would have been payable had the out-of-network provider been in network. And these tie back to the billing restrictions that I'll talk about now, but essentially the reasons to disclose are twofold, and once again, we're recommending all disclosures be made in writing and saved in the patient's file where possible. All right, so billing restrictions. So I guess to talk about this generally first, and this is noted towards the bottom of the slide here, a recurring theme throughout the Act is that patients must knowingly and willfully consent to receiving services on an out-of-network basis, or such charges will be subject to reimbursement reductions. And when I say reimbursement reductions, I mean that generally when the legislature drafted this Act, they wanted to, sort of set aside these scenarios where they don't think it's fair for a patient to be charged above the in-network deductible or copay because they were either unable to consent or they were not aware and therefore could not consent because they didn't know they were receiving out-of-network services. So I'll describe these two scenarios a little bit more detail now. So the first one is emergency or urgent scenarios. So think about, when a patient is brought into a facility or a practice unconscious and they're unable to consent to receiving out-of-network services. Or, for example, say that a patient comes in and they're losing blood, and although they're still conscious, there's really no time for them to consent to these disclosures. They need to get into the ER now. They need to be taken care of, or there could be serious issues. The Act basically states that in those scenarios, the patient can't consent to receiving out-of-network services, and because of that, they can't be charged above whatever copay, deductible, or cost-sharing amount they would have had to pay had they been in network. The second one, which is slightly more complicated and goes back to the disclosures I was talking about earlier, are scenarios where the out-of-network services are provided inadvertently. So basically what this is referring to is a patient sets up an outpatient procedure at a facility like an ambulatory surgical center. And the ambulatory surgical center is in network with the covered person / patient's health plan. They go there, they receive whatever procedure they needed to receive, and then they get a bill in the mail and they find out the anesthesiologist who they received anesthesia services from during the procedure was, even though they thought they would be receiving all in-network services, that person was out of network, and now they received a bill for out-of-network services. Because they didn't realize they would be receiving out-of-network services at the time that they scheduled that facility admission, they or their health insurance carrier will have the ability to essentially contest that charge, which leads into the arbitration system. Before I get to the arbitration system, I just want to touch briefly on these two quote-unquote miscellaneous other provisions. They really relate back to the other stuff, but because they don't tie in as nicely and I can't give them a nice title, I'm calling them other provisions. So the first one is actually an import of a federal restriction, which is the ban on the waiver of cost-sharing amounts. And the second one is the arbitration system, which handles billing disputes. So to touch on the ban on the waiver of cost-sharing amounts, I'll give you a little history on this. So essentially, at the federal level, this has already existed for Medicare and Medicaid beneficiaries. And essentially, what the federal government is trying to prevent is a scenario where a practice will routinely waive patients' copay or deductible that a Medicare or Medicaid beneficiary, so that they'll choose to receive services at that practice rather than a practice that they know they'll have to pay their copay or deductible. This has now been incorporated at the state level, so it's now applicable to all New Jersey practices. And essentially, it amounts to the same ban. There are two major sections here that I'm just going to touch on briefly. The first one I already sort of mentioned, which is essentially this bans the routine waiver of cost-sharing amounts, copays, deductibles, stuff like that. Essentially, what the Act says is that doing that routinely is viewed as an inducement of the patient, and therefore it's restricted. That being said, there are exceptions to this. As noted in the slide, there are federal exceptions. Since this was a federal restriction, the state law actually incorporates the federal exceptions. One example of a federal exception would be if your practice has a reasonable and subjective, or rather objective, policy that deals with whether or not a patient has, for example, a bona fide financial need, then that's permitted. So if the practice has a written policy that sort of goes through what steps the practice will take to determine if a given patient has a bona fide financial need, then that's fine. There's also one other restriction I'll mention. The Act also specifically states that practices now need to make commercially reasonable efforts to collect before writing off any amounts as bad debt. We're interpreting this to mean generally 3 attempts. Obviously, it can vary based on your specialty, but the trick here is to really focus on the industry standard because we're trying to meet a commercially reasonable goal. All right, so now to sort of move on to the new arbitration system. This is, as I mentioned earlier, there's those restrictions on billing amounts. So what this system basically does is it serves as a dispute resolution system in scenarios where you as a provider stated that, you provided your correct disclosures to a person. Now they're saying they never received the disclosures. They thought they were receiving services on an in-network only basis at a facility, and therefore their insurance company or they are claiming that the services costs were excess. So this system is sort of meant to promote negotiation between the parties to resolve the billing dispute. And if that doesn't work, it provides for a mandatory arbitration. So essentially the way this works is that after receiving their bill, the patient or insurance carrier has 20 days from the date they receive the claim to make an additional claim, which there's a form for on the New Jersey Department of Banking and Insurance's website, that the bill is excessive. And we already discussed the reasons for that, but they would have 20 days from the date of receiving the bill to make a claim. After the provider received the claim, it creates a 30-day clock which starts ticking, which I guess I'll refer to as sort of the negotiation period. So this is the period where the insurance company or patient can contact the practice or facility and start trying to negotiate, what they'll accept, say what evidence they have of, what disclosures were made, how much they think the bill should be, what they're willing to pay, etc. If after 30 days the party's final offers to one another are still more than $1,000 apart, either party, so either the provider or the patient/insurance company, can initiate a binding arbitration. This has to be initiated within 30 days of the 30th day of negotiation. So 20 days to make the claim, 30 days after that to negotiate. On the 31st day, the 30-day timer starts going on, how much, whether or not you want to make a request for a binding arbitration. If one party decides to make a binding arbitration, they would essentially submit a claim with a form that New Jersey Department of Banking and Insurance has provided. It's on their website. Essentially, from August 30th, 2018 through August 30th, 2019, we know that Department of Banking and Insurance is going to use its current vendor for the independent claims payment arbitration system. It's known as Maximus. Essentially, this would be an online arbitration system. You'd submit a form, the New Jersey DOBI form, into the Maximus database, which would then essentially start an automated arbitration process, which would be handled by an American Arbitration Association arbitrator. The arbitration itself would be what's known as a baseball-style arbitration. So what this means is essentially that the arbitrator is restricted from what amounts to award. He can only choose either your final offer as a provider or the patient or insurance company's final offer, and he has to pick one of them. And the reason for this is because it promotes the parties to pick more reasonable final offers that will be sort of closer together, out of the fear that if you pick something really out of the ballpark, then it'll kind of force the arbitrator to pick the other one, even if he thought it should be a higher or lower amount than that. Another important point to make, the cost of arbitration will be split evenly between the parties. This is an effort to, reduce the ability of insurance companies or providers for weaponizing this provision to essentially, cause the other side to have to bear the costs. The costs are always split evenly here. And then a final note on the arbitration system is that payment of the amount determined to be due becomes due and owing 20 days after the arbitrator makes his or her decision. The final thing I just wanted to note on here is penalties under the Act. These aren't really well defined, and we're expecting that the Department of Banking and Insurance and the Department of Health will, they'll promulgate regulations that give us more specifics on this. Right now, we know that the penalties can range from $100 per violation per day up to $2,500 for each occurrence for healthcare professionals, and from $1,000 per violation per day up to $25,000 per occurrence for healthcare facilities and carriers. Further, as I mentioned earlier, upon a finding that a healthcare professional has failed to comply with the requirements of this Act, including the payment of a penalty, the Commissioner may refer the matter to the appropriate professional occupational licensing board. So essentially, this means that this can be referred by either department to your appropriate medical board. So, the Board of Medical Examiners, so on. So in terms of next steps and recommendations, there's a couple things I want to touch on. First of all, I want to just go over some things I mentioned earlier. We're recommending, any disclosures that you can make via written form that's signed by the patient and stored in their file. Please do that. That's the best thing that you can do to protect yourself and create a record that you gave the proper disclosures. In addition, you need to make sure that you're in compliance with the various requirements that need to, for example, on your practice website, your facility website, your health insurance benefit carrier website, and that all of the disclosures that need to be provided to the patient, in addition to those website disclosures, are there and in a reasonably accessible form. Sort of branching off that, consider speaking to an attorney to ensure that your practice, facility, or carrier is in compliance with all these requirements. This may require updates to your disclosure forms, to your website. It may change the way that you do patient intake, but as I stated, this has been effective since August 30th, and you're expected to do this, so please make efforts to contact an attorney and make sure you're in compliance. In addition to that, consider speaking to an attorney about developing a cost waiver policy if this is something you deal with on a pretty constant basis, especially if you deal with a lot of indigent patients. You really should have a written policy in place, and you should be keeping proper records of any time where you do decide to waive any cost-sharing amounts for, either a bona fide hardship or because, you just can't seem to get payment from the patient after making commercially reasonable collection attempts. Finally, stay on the lookout for updates and additional regulations clarifying and expanding on the provisions of the Act. This bill is super complicated, and to be frank, there's still a little bit of vague space.
Oh, I think Brandon may have cut out there for a second. All right, well, I know Brandon was finishing up right now. I don't know what happened. Fortunately, he cut out. We lost him. But that was basically, I believe, his last point. What he did want to mention is that there are new regulations coming out. So please be on the lookout for them because of the fact that, this is a new law and it's, a living, breathing thing that's expanding. We also have a number of questions, which is very understandable because of the fact that these are very new laws, and we have quite a few related to, in particular, the employee sick leave law. What we're going to do is we may not have enough time to answer all the questions. What we will do is we'll take the time right now to answer a few of the more prevalent questions that we're seeing. And then what we'll do is we will prepare basically a Q&A document that's going to have everyone's questions and our answers, our responses. You can email myself, you can email Romana, you can email Brandon, you can email all of us. And we'd be more than happy to, provide you with any follow-up information that you need. Romana is one of the things that she does as part of her compliance plan is she does look at the current employment contracts that you have, possibly in your employee manual, to make sure that nothing in there conflicts, to make sure that it all complies with the law, and you may have to redraft or revise some of that. So that is part and parcel of the type of work that she does to bring practices up to compliance. Brandon, part of his job, what he does is when he gets contacted for a compliance plan is he does just that. He sits down with the practice, gets a good idea of, the mix of out-of-network versus in-network, and then he comes up with the individual notices that need to be given out. Although they are to an extent formulaic, it's not something that's just a form. They have to be somewhat tailored, and he works closely with practices. He comes up with everything that they need as part of their compliance plan, which is more than just putting a form in a envelope. And he also goes to the practices and gives specific training to the, practice manager and anyone else there. It could be the doctors, could be the staff, anyone who wants some training. So if either of you, or if anyone here is interested in, learning more about this or instilling a compliance plan or having some of your records reviewed to make sure that you're in compliance with the law, the new law, please feel free to reach out to Romana and Brandon. I'm going to turn it over to Romana right now to answer a couple of the questions that she saw that were a little more prevalent. And then as far as the rest of them go, we'll send it out to, all the attendees so that you know exactly, what was asked and what our responses are. So, Romana, if you don't mind, if you want to take a couple of questions that you saw.
Sure, no problem. I'm just going to try to cover a couple of the ones that I kept seeing come up with the questions that came out. One of the questions that was asked was define family members. We did briefly touch on it, but generally, with the Paid Sick Leave Act, the family member is essentially defined as a child, grandchild, sibling, spouse, domestic partner, civil union partner, parent, grandparent of an employee, and then it includes or any other individual related by blood to the employee or whose close association with the employee is the equivalent of a family relationship. So as you can see from that definition, it is very broad. It covers many different relationships. So that's, if you're taking into consideration, what who it is and who it is that's related to your employee that they're taking this time off for. Keep in mind, when they say close association with the employee that's equivalent of a family relationship, that's covering a lot of different categories there. And another question that was asked, who are covered employees? I think this is, again, one of our more general definitions. I think it's important to cover it again. Covered employees, again, very broad, applies to most employees working in the state for compensation. That's really the definition that they have put in the Act. So it covers both full-time and part-time employees. They do have a few exceptions to that or a few exclusions. For example, the per diem healthcare employees would be accepted. Public employees that already have sick leave benefits would be accepted. But again, it's a very, very broad standard there. Along the same lines, we had a question that says, I have less than 10 employees. Am I covered? Less than 10 employees. For a definition of a covered employer, remember that size is not going to matter. So whether you have 10 or you have 100, it is all going to be covered for purposes of the Paid Sick Leave Act. It's not like the FMLA or the NJFLA that have a 50 employee size limit. Here, it's going to be irrespective of size. Let's see, with another question that we had, is it better to front load the days for the year as opposed to allowing them to accrue? Keep in mind the Act allows you to essentially pay these or give the employees these days using the front loading mechanism or the accrual mechanism. Is it better to front load? It may be easier to front load. I think a lot of our clients that we've spoken to already have chosen to front load only because it's just simpler in terms of calculating, instead of having to run a tally every week or calculating the accrued time, they're able to front load. But with a part-time employee or someone that's hourly, it may not be as easy to do that, and accrual may be the better option. Let's see. Is there a time limit for carryover days? So I think this question relates to at the end of a benefit year, the option to either carry over any unused time or to pay it out. The time limit for carryover, is there a time limit for carryover days? No, there's not necessarily a time limit per se, but what the law does do is it essentially says that you can carry over up to 40 hours of time in a given year, and you don't have to carry over more than that. And then during a given year, a benefit year, you do not have to allow the employee to accrue to use more than 40 hours. So even if they have more than 5 days of sick leave in a given year, you are not necessarily obligated to allow them to use more than that. Let's see.
Just one thing to chime in. I know that someone asked about do the laws on out-of-network pertain to outpatient medical practices, or is it just hospitals and ASCs? And Brandon advised that yes, practices, out-of-network practices are included under the general provider and physician requirements. Also, registered surgical practices will be subject to the facility requirements once they are required to become licensed next year, which goes, again, hand in hand with the fact that this is a constantly evolving issue. As things change, the out-of-network law is not going to get, smaller. It's going to get bigger, and it's going to be more all-encompassing. One question, actually, Romana, that I think I've been asked quite a bit too. That I don't know if you could provide an answer to us for is what happens, we're already in December, so the year's almost over, but what happens to those employees who had PTO, which included some sick time this year, 2018, and they used all of their PTO days before this law came into effect? Are they entitled to any sick leave for 2018?
So technically, pursuant to the law, as of the effective date of the act, all current employees would have started to accrue time. So the accrual would have began on October 29th. So even if they've used up all of their PTO time, arguably as of October 29th, they've started to accrue time again between October 29th and the end of the year.
So it would still start accruing that which carries over
right.
to 2019, correct?
Yep, that's correct.
Okay. And if there's one more question that you want to answer, we'll finish it with that, and then we can send it off. Or
Sure.
if Brandon, if there's a question that you'd like to answer, you can as well. I think we have you back.
Yeah, I'm scanning these quickly to see if there's any I can.
I think we just had a question come up about whether part-time employees can be treated differently than full-time employees. Technically, the law does not create a designation between or a difference between part-time and full-time. The bottom line is that both are covered as covered employees. I think just as a practical matter with a part-time employee or someone that's, not working the full 40 hours, it may be easier to allow them to accrue the time rather than to front load the time of sick leave that would be granted. But beyond that, there's not necessarily a distinction between the two for purposes of the Act.
Well, we're running up to the end right here, so I want to thank again everyone for spending their lunch hour with us, learning about this. This is something that we're going to continue to offer and provide to all of our clients and our friends, of course, who are in the same boat that we are. We're trying to do our best. You guys for your patience, us for our clients, and it really is a group effort here. Frier Levitt, we have over 35 attorneys, all specialized in healthcare law. I'm, very happy to be working with such knowledgeable attorneys as Romana and Brandon, who can certainly teach me quite a bit about things that I had no clue about. I will say that in a lot of the work that I do, which is representing, doctors who are getting audited, doctors who are being sued through a, False Claims Act case or anti-kickback, and board matters, that a lot of what they're talking about, I'm already starting to see complaints before the Board of Medical Examiners about out-of-network bills. And I've definitely have been seeing a lot more complaints that are employment related, that are, a former employee against a physician and things of that nature go before the board. So all of this is connected. All of this, is symbiotic. And I want to thank all of you for your time. And I want to thank as well Romana and Brandon for giving us more of their, expertise. We'll send out to everybody, like I mentioned before, a Q&A with all the other questions we didn't answer that we had here. And wish everybody a great holiday season. And we'll let you know when we have our next one, which we, are looking forward to. Thank you very much, everybody.